Hello and welcome to Legally Speaking with me, Tarun Nangia. We all know the Chief Justice of the Delhi High Court, Justice Satish Sharma, uh, issued that order whereby, with his consent, what is happening? Delhi High Court is going to continue in hybrid mode now till further orders. Today, we are going to delve upon this issue that how Delhi High Court is becoming progressive with faster adoption of hybrid method of hearing, how it benefits the litigants, how it benefits the lawyers to have such a mode. Are there learnings for any other high court in India that they can take from the nimbleness of the Delhi High Court? And for a city which is in attention globally, being the capital of India, what happens in Delhi High Court is watched by everyone all over the globe. So we are going to discuss the benefits, and of course, we are going to delve, are there any drawbacks of the hybrid hearing mode? And to discuss this issue, I have a very eminent guest with me on this edition, which we have titled Saturdays with Sikri. Yet again, we welcome Justice Arjun Kumar Sikri. Good to see you, sir. And
thank you.
As we all know, sir has served as a judge of the Supreme Court of India, is currently one of the country's foremost arbitrators, as we all know. And also, he is a judge at the Singapore International Commercial Court. And sir, if I may ask you, you now have a multi-jurisdictional experience of Singapore, being a judge there, experience of being a leading arbitrator in India. We all know you do a lot of online hearings yourself, where you are hearing. So 2 minutes with your experience, and then we move to the Delhi High Court.
Yeah, if I may say so as an introduction, you see, as far as technology is concerned in the judicial system, in India, elsewhere as well, in other countries, and in India also for the last 15, 20 years, we have been thinking that, yes, this technology is one thing which may the judicial system can take help of, and it will go a long way in resolving many problems. And particularly when the Indian courts are plagued with arrears of cases, and when we talk of case management, court management, and access to justice, easy availability of various services of the courts, etc. So without stating much in detail on that, but that had been going on as far as technology is concerned. But when it comes to virtual hearing or hybrid hearing, that had not taken place except in one or two marginal areas. Like I give you an example that when it comes to the prisoners who are under trials, etc., are produced in the court for remand. So way back almost 15 years ago in Delhi, and then it started in other courts also, that from jail, from Tihar itself, the people will come, those prisoners would come and on the line, and remand orders would be, so they don't have to travel all the way and go back. So only for these things. And in some parts of the country, some high courts had experimented, I would say, and it was not a routine, but experimented with virtual hearing, where in high courts where they're distant, because Delhi is capital city, it is a small city state. But then there are many very big or large states where persons have to travel a lot. So if some advocates want to appear from official courts, so I remember some of the high courts have said, okay, we'll allow you, you can appear from there online and argue your case. But when the COVID came, and as we say, the necessity is the mother of invention. And we realize the importance of virtual hearings, because courts, as I always say, that the judicial system is also that service which is essential service. And during COVID, when other essential service could not be, halted or stopped, they were required. Likewise, deciding those cases which are very urgent, that was necessitated. And therefore, we turn to virtual hearings. We use the technology now with full force. And all I must appreciate the efforts of the Supreme Court, their E-Committee, and all high courts. So all worked in that direction, and it started happening. But Tarun, what I want to say is that it was because of the corona or COVID reasons. So it was out of, in a way, we had no other choice. And that is why it was happening. But what was realized was, and that is why we started discussing this discussion took place in media also, intelligentsia also, legal, those who are stakeholders in legal system also, that why not it should continue even after the COVID effects are going away or fading away, and we are coming back to the old normals. Still, at least in hybrid form, the hearing should continue, because many benefits of such hybrid hearings were found. And it didn't happen only in judicial system, as you rightly mentioned, and the arbitrations started taking place, even mediation to some extent. All various tribunals were holding the sittings, online sittings. And another thing which started, of course, it has to take off that kind of shape which we need in this country, which we call ODR, online dispute resolution. So these are all, I would say, reforms in the judicial system, which will take care of so many problems which we are facing today. And therefore, technology in that sense for hybrid hearing or virtual hearing should continue. That is what I would say.
So Justice Sikri says technology should continue. He is a votary of the hybrid system and the digital system of hearing cases. Sir, I would like to ask, the Delhi High Court under the Chief Justiceship of Justice Satish Sharma has taken a progressive step. Immediately they saw the cases were rising. They said, let's shift to hybrid mode. What benefits do you think will accrue, firstly, to litigants and then to lawyers with this kind of a decision? Because, of course, with every decision, there are some merits and demerits. First, we go into the merits. What are the merits you see that will accrue to the common citizens, the litigants, and then the lawyers also who practice in Delhi High Court?
You see, when we again, this has happened because of COVID cases which have started rising in Delhi again, and not in Delhi only. I've seen Delhi all over India and even in many other countries. In Europe, still that problem is there. In many Asian countries, I had gone to Singapore 2-3 weeks ago. There also cases are rising, and other Asian countries, even China and other countries, the cases are rising. So what is the problem is this COVID, you see, which started end of 2019. That is why it was given name COVID-19. And it has not gone away totally. I mean, maybe we have some patches when we feel that, okay, now the positivity rate or the COVID positive cases have come down substantially and it's almost over. But then we again start, we find that this trend that the cases have started rising again. So we don't know how long it would continue. And again, I would say High Court has done. We have to appreciate it. No problem. Doubt about it. That they took a call when the case, and maybe because now of most of the people are vaccinated, and the effect of COVID is not that serious, which it used to be earlier, and it is like now any other flu, etc. But main problem with COVID is that it is transmittable. So if a person who has suffered COVID, unlike other virus, and if I've got flu or I've got something that may not be, even if I go out, it may not affect others. But as far as when COVID is concerned, then a person has to be segregated from others, and he has to, he can't be mixed with others because he will spread. Now, this kind of fear is there, and because of that, COVID, this starting of hybrid system is really a welcome move. It is just to take care of a COVID situation today, which is becoming alarming. I would say, we are not able to feel the effect of that because, as I mentioned, that it is like any other flu. And there is a limit to which the people have patience. Now, they have lost their patience. For how long we will confine ourselves in the homes, etc. But then there are certain places where precautions which need to be taken are, required are much more, like cinema halls, like, malls, and courts also, where thousands of people throng every day. So therefore, when there is a hybrid system and people can join from on say computers there, and from any device, even from phone, so many litigants would not like to come. They'll say, okay, we can see, if I have a case, I can see my proceedings. Likewise, many advocates, those particularly who are of old age, would not like to, in such a situation, would they like to go to the court when they can argue it. And even it applies to young people also. So therefore, that is there. But as I said earlier, that, okay, hybrid system because of COVID, but if COVID is, let us presume a situation where COVID goes completely and there's no such problem, why not still we should have hybrid system? Because of many advantages of this. Now, I give you example, as you have rightly mentioned, about mediation. Arbitration, which I am doing. In these last 2 years, I must have done 5 or 6 international arbitration. As far as domestic arbitrations are concerned, there's one or the other hearing almost every day. One case, 2 cases, even sometimes more than that every day. Now, first coming to those even international arbitrations, now you see the advantages. Online arbitration, where the witnesses are present in different jurisdictions, different countries. Lawyers are from another countries. 3 arbitrators who are appointed are from 3 different countries. So if there were physical hearing, suppose Singapore or London is the place of arbitration, or what we call seat of arbitration, at least 20, 30 or even more persons will assemble there for that particular case from all over the world. How much expense is saved? How much time is saved? And my experience is that we have been able to, and it is not only my experience, everybody, there are so many colleagues of mine in domestic arbitrations who have been co-arbitrators, etc., or even international arbitrations who are from other countries. They say that it is going on smoothly because all institutions, whether it is LCIA, London arbitration, Singapore arbitration, ICC, Paris, ICC, Singapore or Hong Kong or even Dubai, etc., they also, amended or rather formulated or prepared and came out with the rules or the protocols as to how the virtual hearings will take place. And therefore, and they take care of due process, which is most important, that yes, the witness which is examined is not tutored, the persons are able to argue properly. So all that protocol is stated there, and this is now adopted by major arbitral institutions. So therefore, because of that, and after following that, no problems are being faced. So, and hybrid, which I saw in whenever there was some, say, in India as well, domestic arbitrations. So ease insofar as the COVID effects are concerned, for recording of the witnesses, statement, etc. Many times the party would say, no, it should be recorded in presence of the other sides. If I am cross-examining the witness of the other side, that witness should be present in my presence. He should be there and we should be physically present. And so that I'm able to see the person is not consulting any paper, he is not tutored, he is not guided, etc. All those things which are very important, no problem. But then we started, in many cases I have done, and many of us have done, hybrid system, where some who can appear from who can appear online and join online would join, including the arbitrators, whether it's a sole arbitrator or 3 arbitrators. But then the 2 sides, they would hire a place, a big place, so that they are not sitting quite close to each other, and witnesses are physically present in person and they are argued. So this kind of hybrid system we have adopted even in the arbitration. And so whether it is international arbitration or domestic arbitration, wherever it is required. So hybrid, in a way, what I would say is that if online or total virtual hearing may have some issues, say regarding, as I said, due process or proper cross-examination of witnesses, etc. And sometimes the documents are the volumes in arbitrations, particularly in thousands, and you have to confront the witness with a particular document and have to ask answer. So it may become sometimes little tedious that you are sharing that document on screen, the other side is reading, but when you are sitting across, it may happen. So therefore, those things are I would say weaknesses of the total virtual hearing are taken care of in a hybrid mode. That can be replicated in the courts as well. Now, as far as courts are concerned, again, many times what happens, suppose a person is, I have to appear in Supreme Court or Delhi High Court, and I'm a lawyer in Bombay, and vice versa. Many lawyers from Delhi, they keep going to Bombay High Court, etc. Many particularly come to Supreme Court on Mondays and Fridays from all over the country. Suppose at a last moment, the person is not able to take the flight, that advocate, correct, who has to appear, or he has he's affected with something which, because of suppose he has sprained his foot, he is not able to walk, but otherwise he's fit. He can always argue the matter. So why adjournment should be taken in such a matter? If he makes a request in the court, hearing is going on, but one lawyer is allowed to join in a hybrid mode, and he can come. And it applies to, as I said, witnesses as well. If suppose in a court, now I'm talking of court case, a trial is to go on and the witnesses are outside. Many times I have seen from my experience as a judge when I was, many times adjournment would be taken that witness could not come because of XYZ reason, and not because of physical ailments, etc. But such a witness can join if allowed to join online. So again, this hybrid system comes handy. So it not only saves cost, as I said, but many times saves time also, and there would not be unnecessary adjournments, and the cases would go on. So technology, the hybrid system in that sense is very helpful in so many ways.
So I want to also understand from you, 6 years ago when I interviewed you once, you had told me in a certain mediation case, you wrapped up that matter, which was a settlement between one lady and 4 or 5 brothers within a period of 5 days. And I remember you had told me that long ago that you wanted this mediation to be settled ASAP because that lady couldn't have traveled from Canada to India often. It is expensive, it takes time. Now let's, in a sense, compare this with litigation in Delhi High Court or the arbitrations that you regularly engage in. Do you think the simple imperative that a lot of money of litigants will be saved on travel and stay and also time is a compelling enough reason to have it in permanence? And secondly, for example, we make Delhi High Court as a model High Court. Would it be good if we give Delhi High Court, say, a one-time grant of, I'm just giving out numbers, but that doesn't mean anything, say 1,000 crores, to have a modern court hall with sound deadening material, acoustics, so that when you hear, you actually feel the person is standing in front of you and we have this technology easily available. It's just that the courts don't have it. Do you think time has come to think forward with the court infrastructure to suit hybrid?
Yeah, I think you have hit the nail on the head. And that is, once we have now realized that wisdom lies in having these hybrid hearings, and it would be good for the system, and it will be able to resolve so many of the issues which we are grappling with, including judicial reforms, etc., then why not? And you have rightly said that, look, in such a case, as first example you gave, where that case was settled and the lady was coming to had to come from, because she was their sister, no doubt, but she had been married, and so she was living in Canada. So case is here, she had to take her share in the property. So it was very difficult. It would have been. And as you know, the court system, the way it works,
Yes.
and coming every time, every second month or third month from Canada and traveling to, because it was a case when I was Chief Justice in Punjab and Haryana High Court, so in Chandigarh, they belong to Punjab. So it would have been difficult. And in mediation, the case got settled in 3-4 days. And she was happy. She got her share and went back. And as I said earlier, also, then a person like that becomes ambassador for Indian judicial system or legal system. She said that, look, people unnecessarily criticize Indian system. I would go and tell all that, look, I could get the relief within 5 days, whatever I wanted.
Yes.
So therefore, that is one part. And second, as you, it's a very good suggestion, Tarun, which you have given, that why not start it as a pilot project? And Delhi High Court is taken as the model court, and which is in any case, doing so many such things and have taken so many initiatives which are followed by other courts later. So why not then the government invest some amount and where we create wonderful infrastructure. I give you a very interesting example of Singapore Supreme Court. Now, till few years ago, maybe 10, 15 or 20 years ago, Singapore Supreme Court was in a heritage building, a wonderful building, and like we have in our Supreme Court or other courts. Now, they decided to shift from that building and to construct a totally new building because they wanted the as far as technology is concerned and computerization is concerned, it should be to the hilt. Every possible thing should be there, which would be difficult to have set up that kind of infrastructure in an existing building. So therefore they came out. I still remember at that time I was High Court judge. And when we had gone, I had met one of the judges of the Supreme Court there. And Justice V.K. Raja, who has given that pass as an emergency order, he has become famous in India in that Amazon case also. But then I said that why such a beautiful building? Because we saw that building and then we saw the new building also. He says, no, but we want to go ahead insofar as the justice delivery is concerned. Yes. So maybe it's a good building when you go there, but what we have created is a modern building. It is not also bad, yes. But then the main purpose is access to justice and to give speedy justice at lesser cost. So therefore, already as far as the legal system is concerned, is plagued with the delays and cost. So therefore, why not? Wherever we can save the cost, and by hybrid mode, we can save the cost substantially, as you very rightly pointed out. So why not, even in normal times, we should not have, like I said, that hybrid system is introduced in the Supreme Court because, High Court, because COVID cases have started going up. I would rather beseech the Chief Justice and the judges of the High Court that even when the normal conditions get, you take, let there be a roadmap prepared. What kind of cases we can still go on in a hybrid mode where we give choice to the people. And in order to do that, as yes, government should invest in technology in one particular court, in Delhi High Court, which has a very interesting suggestion or very good suggestion which you have given. It will go a long way. I give you example of my, in Singapore's international court, this commercial court. I had one hearing after, because the hearings were taking place in virtual mode there also because of COVID. But with the ease of COVID now, the physical hearings have started. In in July, 18, 19, 20 July, hardly 15, 20 days ago, I was there for 3 days. There was one case hearing was to take place. So therefore, there was one judge from their own court, Singapore. I was from India and one was from Paris. So we 3 judges were there. We held this physical hearing. After 1 week only, I had another case, another hearing on 26 or 27 July. So, but this was, and there the parties were from different countries. They wanted virtual. The 2 judges from Singapore sat in the court. I joined from Delhi. So, and it lasted because it was Court of Appeal, final Supreme Court. And like you know, that it won't take time. That there was already an arbitration award, and then the SICC had already gone through that. And now we were in appeal. We were hearing the final appeal, like our Supreme Court. So they call it Court of Appeal within the Supreme Court. So therefore, we knew it would not take time. They said that why you come all the way from India for 2 hours for this purpose, and why? Because they were the parties were from different countries. One lawyer was from other country, one lawyer was from Singapore. So the hearing went on in a hybrid mode. So here is an example of hearing in person, physical hearing on 18, 19, 20th July, and on 26th July, one hybrid hearing, wherever it was possible. And I have seen the infrastructure which they have created and the technology which they have introduced is really remarkable. And if we have that kind of, we can, of course, not that we are lagging far behind, we are also doing very well. But yeah, why not reach that stage? Why not improve it further? And let the government spend that time. I think we should, this program of yours, maybe that somebody in the ministry or maybe our law minister or somebody watches this and says that, yes, it's a good idea and we should do that.
That's a good. Thank you so much for so much of insight into this issue. We also hope that this happens. Maybe just the Chief Justice's court in the Delhi High Court could be the start. And as you suggest, a modern building. And we see that most of the ministries are now getting modern buildings. So why not the Delhi High Court to get a modern building? Thank you so much for all the insight you shared with us. And in the next edition of Saturdays with Sikri, we will deal with another aspect of Delhi High Court. But that's under wraps as of now. And again, this issue of modernization of Delhi High Court and hybrid mode of, we will revisit in a month on Saturdays with Sikri. But that's it for now, viewers. Thank you so much, sir, for joining us. Thank you so much, viewers. Thank you so much.
Thank you. Thank you.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.